Hi, everyone. Thank you all so much for being here today and spending an hour of your Friday with us for today's very timely and relevant session, Legal Rights of Immigrant Students in Pennsylvania Schools with Kristina Moon from the Education Law Center. I am Megan Dale from the Center for Schools and Communities, and this session is being offered as part of our Pennsylvania Refugee Education Program's quarterly learning series, Together We're Better. So our session today is led by Kristina Moon. Kristina is a senior attorney in the Philadelphia office of the Education Law Center. She supports ELC's litigation and policy advocacy across all issue areas. Kristina's current and recent work includes ELC's lawsuit against the Commonwealth of Pennsylvania for a more adequate and equitable school funding system, and ELC's campaign for inclusive schools and honest education. She also supports advocacy on behalf of immigrant students and English learners and LGBTQ students. Thank you so much for being here, Kristina, and sharing your expertise with us. We are very glad to learn from you today so we can continue to all best serve our immigrant and refugee students and families during these uncertain times. Thank you so much.
Thank you, Megan. Hi, everybody. Welcome. I'm so glad that you're here and interested in learning and sharing space to talk about how we can support our immigrant students in our public schools. I am a lawyer, and so I need to start with a disclaimer that I or Education Law Center Pennsylvania do not represent the Pennsylvania Department of Education or the Center for Schools and Communities or any of you attendees. So this will not be specific legal advice. This is public education about the state of the law. And we always recommend that you consult your own lawyer or solicitor for specific legal advice about your situation, your students, your schools. We do offer this type of presentation because we have received so many messages and inquiries wanting to understand the legal issues in this context and how to ensure that schools are following the law with respect to the rights afforded immigrant students and potential ICE enforcement action in or around schools. We do have an open letter posted on our website to all public schools in Pennsylvania from the ELC and the ACLU of Pennsylvania that provides legal citations for all of the issues and particulars I'm going to go over in the slides that don't have legal citations, but that letter does. That will be linked in this material, and I will provide a PDF of these slides with a lot of links within them to Megan to distribute to everybody registered or attending after this presentation. And that there is a lot of material to cover, but I will try to leave some space. So please do feel free to, keep in mind your questions, and we'll try to get to them at the end, or certainly we can do a follow-up presentation or session. So agenda, we are going to try to cover a lot about enrollment, non-discrimination, and then specifically ICE enforcement action and some recommended protocols. In case anyone is not familiar with Education Law Center Pennsylvania, we are a nonprofit offering free legal services for focusing on the mission of ensuring all students in our public schools in Pennsylvania have access to a high quality public education. We do have a statewide helpline. The number and email are there. Any individual parent, older student, or advocate working with students can call that helpline, leave a voicemail. We do have language access services available, so leave your message in any language that you need, and we'll call back with an interpreter. And we provide legal advice, resources, and we also come from that helpline. Some of what comes from that helpline is individual legal representation or identifying impact litigation where there are systemic issues that we can identify. We also provide policy advocacy to school board level, state level, and national levels that impact our public schools. And we offer trainings like this, as well as a lot of written resources, including fact sheets and making open letters that include our advocacy to show folks our concerns here. A little bit of context, which you all probably are very familiar with already, working with students and families yourselves, but here in Pennsylvania, 1 in 4 residents is an immigrant, and an estimated 19% of that immigrant population is undocumented. There's a significant number of unaccompanied children released to Pennsylvania in recent years. And we have here just some examples from high population cities and regions. We do have a rich immigrant population here in Pennsylvania. We have seen an unprecedented is a really fair word, unprecedented number of executive actions from the federal, the president and related agencies regarding immigration and immigrants since the January 2025. This is not even a complete list, but it is a sample of the types of actions that are getting recognized in the news and really are cause for concern and great fear among our immigrant populations and all of their families and loved ones, because it is really a very intensified scene right now for anybody who is paying attention. It is a very significant climate of fear and trepidation everywhere across the country, and certainly for our immigrant students. So we'll get into some specifics about these, but it's worth noting that this is a lot, and it's not even a complete list. One flag here that is not quite this specific education area, but it has also been in the news about some, you may have heard about some attempted changes to what is considered a public benefit and how non-citizens can access public benefits. This is not quite my area of expertise, so I won't go into here, but there are links to further information. And the real takeaway is that there are actually no changes required for schools based on this attempted proposed rule and guidance change from the Trump administration, because the statute has exceptions for the school context regarding basic education access and school and lunch breakfast eligibility for schools. And there are lawsuits challenging the proposed change as well. So takeaway is keep an eye on this, ask your solicitors to be following it for you, but there's not a required change at this time for schools. We do also have some federal executive orders regarding language access. There was a presidential executive order designating English as the official language of the United States, and the rescission, meaning clawback, it is no longer effective from the 2015 Dear Colleague letter that's referred to as the Lau guidance. And we'll get into some of that a little more specifically, but it's a point to clarify here that what is an executive order, and we're hearing about this a lot. Presidents long before Trump have used executive orders, of course, but they are directives from the president to explain how that particular administration plans to interpret and enforce the law. But they cannot in themselves override statutes or case law interpreting those laws. So a very basic step back. Our laws at the federal level come from statutes, laws passed by Congress, and individual agencies that have been given authority under statute to promulgate regulations or rules that are interpretations and act as guidance about those laws. And then we also have our courts that interpret the statute and the regulations, and their court decisions are legally binding on the jurisdictions over which they have authority. But an executive order from the president cannot override or change statute passed by Congress or court decision from a legal tribunal like any federal court. So it is really just a directive to its own executive agencies to maybe put out new guidance, which again is just an interpretation like this form of a Dear Colleague letter, not law, but an interpretation, a narrative like memo about how this administration sees the law and what their priorities will be. They cannot impose legal restrictions that violate the Constitution or other statutes, or they're subject to court review and to be stricken from the law. There's a good example of this from a new memo from the Trump administration in February 14th, I think, actually. There was a memo relating to diversity, equity, inclusion activities in our public schools, suggesting that they are unlawful. That was challenged in court, and recently a court decided that that was an unlawful interpretation and actually struck that guidance, and it was rescinded. So we do have to follow. I know it's confusing and hard to track everything, but we do have to follow the court's interpretations of these proposals, these announcements in the form of executive orders and guidance, like a Dear Colleague letter. So getting into some specifics about existing, continuing obligations on schools regarding the rights of immigrant students. Pennsylvania law entitles all students, including immigrant students, to an education that provides them the meaningful opportunity to succeed. And this is clear from our 2023 recent landmark decision from the Commonwealth Court from our fair funding trial. The judge in this case heard a lot of testimony and evidence, in particular about the needs of English learners or multilingual students and additional supports that newcomer immigrants need in our schools, and found that all students have this entitlement to a quality education and a meaningful opportunity to succeed. Our schools cannot require information about the immigration status of students or families. So schools cannot ask for information about immigration status. It's been clear in a U.S. Supreme Court decision dating back to 1982 called Plyler versus Doe that held the Constitution forbids discrimination on the basis of immigration status when children are accessing public education. The court recognized that preventing a child from accessing education imposes, quote, a lifetime of hardship. This has also been enshrined in our Pennsylvania law, which says that all students with no qualifiers or exclusions have the right to attend school where they live. And then indeed, they must attend between ages 6 and 18, or they meet the graduation requirements, and they can attend until age 21 if needed. This was also affirmed in a more recent United States Court of Appeals for the 11th Circuit decision in 2012, where the court found that an Alabama statute that required enrolling students to verify their citizenship and immigration status was illegal under the Constitution and struck that down. Folks working in schools know that the Pennsylvania law requires only 4 things before a child must be enrolled in the district in which they live, or a charter that they have access to. These 4 areas are the proof of residency in the catchment or district, proof of age, certain immunization records, and a parent statement about any prior expulsions. Schools have to be flexible in the documents that are accepted to prove these 4 areas of residency, age, and certainly the immunizations and the parent statement about expulsion are a little different. And we have good guidance from our Pennsylvania Department of Education in a basic education circular and an FAQ document that really specifies more and give some examples. You can't require proof of citizenship or immigration status. I'm going to say that many times. You can't require a social security number or a place of birth that could indicate immigration status. There's an exception here that school admin folks may know about, where to be eligible for Title III programs, you have to identify students born outside the U.S., but that is protected in confidential education records and will not be shared. So to get also into the practical documents for determining residency or age that only a U.S. citizen would have, like a U.S. passport or many state driver licenses, cannot be the only thing that you accept at the school. Again, great Pennsylvania Department of Education guidance on this, giving examples of a non-exhaustive list of examples, including a baptismal certificate or record, even a notarized statement from parents, or another relative indicating the date of birth, even prior school records indicating a date of birth. So we really ask that folks working in schools or working closely with schools check your school websites where you list items needed for registration, and make sure that you are very clear and not overstating or misleading folks about the types of records that are required or accepted. Indeed, we suggest, particularly in this context, that school administrators should limit the information that they collect from students, parents, and guardians. Education records really should be limited to the basic student information, and consider that if there's no reason to collect it, you should not be collecting it, because if you don't have certain information, you can't be liable for improperly releasing that information. We really have an obligation here to our families to make sure that we're not putting their information or sensitive identities at risk. We, of course, know from news reports and conversations with educators and families that many impacted or vulnerable families are afraid to leave their house right now in this political context of increased immigration enforcement action. And many students are not attending school based on this fear. This has been documented in Pennsylvania and nationally, and certainly folks working with our communities will have heard this in very real personal circumstances. And we recognize, of course, that schools have obligations to record absences and to follow the truancy law. And schools do have considerable discretion under these laws, and we urge school administrators and staff to take all the available discretion you have to meet student and family need. That is always, because there are always individual circumstances that should be accounted for, and certainly in this context, when you are, the law requires that schools hold a student attendance improvement conference to identify with a parent guardian and the student what are the barriers causing a child to not attend school, and to try to address those, right? So we recognize also this is a sensitive thing to discuss. And we have heard from both parents and the educator side that it can feel tricky to try to identify what those barriers are when you're not allowed to ask about immigration status. And many parents or families don't feel comfortable sharing that information. So we encourage broad questions about whether there is any fear or anxiety about attending school that might be causing the non-attendance. If there are mental health concerns, keeping the child away from school, this can be a basis for excusing absences. And it really, I recognize it really does require significant trust and relationship between the school person and the family. So we really do, for this and all the other reasons before and after, we do really value and, emphasize the importance of significant relationships between the folks at the educator level and the support level who are in contact with families and having these conversations, so that it is among a safe relationship, and you're likely to get more real and actionable information to provide those supports, as opposed to just the robocalls about attendance absences or assigning it to somebody who doesn't have a relationship with this family. We want to note here that the Pennsylvania Code does allow for a temporary period of excused absences for, quote, other urgent reasons. This is in the code a maximum of 3 months, but that does give another avenue for schools to excuse absences. And really all of this is with the purpose of engaging with the student family to identify how we will maintain some kind of education connection for the student. Because if they are, interested in coming in person to school, then we want to talk about how we can make that comfortable, whether it's additional support from a community member or staff who is present and watching and providing some of that supervision outside the school or on the walk to school, or if it is not going to be comfortable to attend in person, what are the other alternatives that we can offer in a virtual or cyber program. This virtual program option does need to be flagged and hopefully a transfer made sooner than later, because there is a new law called Act 47 of 2025 that does prohibit student enrollment or transfer into a cyber charter school if that student was already identified as habitually truant, so 6 unexcused absences, by another LEA. Unless a judge determines that it is in the best interest of the child to make that transfer or enrollment in a cyber charter school. And this comes out of concern for physical safety of students who are not being monitored in the cyber charter context. But it is something to be aware of. And I'll note significantly that it does not apply, that restriction does not apply to transfer or enrollment to a district's own virtual or cyber program, only a cyber charter school. So this is new this school year, and we're happy to take questions and work with folks on that. But we'll also note that certainly district virtual and cyber programs often need improvements to really allow quality language access and quality ESL instruction within a cyber program. And of course, schools do have the requirement under law to teach students who do not know English how to read, write, speak, and understand English. These come from federal civil rights law and cases where courts have interpreted this. As I mentioned, there was a rescission of prior 2015 Dear Colleague letter guidance from the Department of Justice and the Federal Department of Education that was a really helpful narrative document giving examples for schools about how to implement the requirement to overcome language barriers. But the rescission of that guidance document has no impact on the continuing statute and court decisions. So that obligation remains. Schools have to provide language instruction from both licensed ESL teachers, and we need to be providing our content subject matter teachers professional development in order to provide the scaffolding and accommodations for English learners as needed in all subject areas. And a specific program is not required under the law, but it does have to be sound in theory, something researched, and effective in practice. So schools have an obligation to be assessing whether students are actually making progress under their English language development program. Lots more we could say about that, but that's a different webinar. We do also have general non-discrimination protections. Schools are required under federal and state law to prohibit and interrupt any discrimination on the basis of national origin, which does include language access as well. In Pennsylvania, I'll note that our Pennsylvania Human Relations Act, covering all of our public schools, does include ethnicity defined to include physical and linguistic characteristics, and race discrimination includes national origin and specifically Hispanic ancestry also. And I think notable that this is not just like being denied access to a program because of your identity. It can also arise in a hostile environment. So schools need to be mindful and responsive to any school climate issues in this area, including staff or student comments that immigrant children and their families are unwelcome in the school, for example, would be a red flag for me for that a school needs to be responsive to that potential hostile environment under these non-discrimination laws. Okay, getting into some more specifics about ICE enforcement activity. Since 2011, the Department of Human Services, or DHS, had standing guidance and policy that they would not enforce immigration detention actions in certain areas that included public schools and hospitals and churches, in recognition that our communities are safer when all of us can access these community areas. In January 2025, that policy was rescinded. But the Fourth Amendment remains. The Fourth Amendment requires a warrant for search or seizure in any area where people have a reasonable expectation of privacy. And that is, of course, a legal term that we're going to get into. So when we think about warrant requirements in certain areas, we need to think about public and non-public areas. So in public areas, ICE has the authority to approach and question people without a warrant. People still have the right to remain silent and to contact an attorney, but they can be approached by law enforcement officers. In the non-public areas, the Fourth Amendment requires a judicial warrant signed by a federal or state judge unless somebody in control of that area consents to the search. So an agent can arrest people if they have a valid administrative warrant for that person, or if they have probable cause to believe that person is removable from the US, doesn't have current lawful status. And that probable cause can be established through questioning of individuals who disclose their immigration status or documentation that indicates they're non-citizens, which is why the advice is to remain silent. We note also that running from ICE agents has been considered to establish probable cause. So areas that are open to the public, like lobbies, waiting areas, parking lots, considered public, but interior areas that are not open to the general public and those marked private with a sign are considered private under this analysis. For immigration enforcement to search or enter a private area within a formerly protected area under the sensitive locations, so in a public school, the Fourth Amendment requires a valid judicial warrant signed by a federal judge unless staff at those areas consent to the search. So let's talk about consent searches. To be a valid consent search, it has to be, that consent has to be granted voluntarily by someone with real or apparent authority, and the scope of the search can't exceed the consent granted. So if a person with common authority over the area, to note also, there are certainly instances we're all familiar with where more than one person may have authority over an area. If a person with common shared authority over an area is physically present, they can expressly refuse consent and override the consent given by another person for that area. This, if it sounds confusing and uncertain, is why we really stress that schools need to have very clear protocols that are practiced at our schools. Who has authority over granting access to the school? Who can grant that consent to enter and search? Who reviews the warrant documentation to determine the scope of the warrant? That should be the lawyer involved. These are very specific protocol questions that really need to be written out between school administrators and their lawyers, and then distributed and discussed and trained with all of the staff at schools. So some distinctions I've mentioned between administrative warrant and a judicial warrant. The law distinguishes between judicial warrants and subpoenas, but immigration agents have often used, and what we've seen so far is that they are still using administrative warrants, and they don't have the same legal force. So an administrative warrant is, as I said, commonly relied upon by ICE. It is only signed by an immigration officer who's not who is like the ICE agent themselves, or an immigration judge who is an administrative judge, not somebody who sits at a federal or state court. The administrative warrants do not authorize ICE agents to enter areas of school property that are not otherwise open to the public. to enter those non-public areas without a judicial warrant, relying only on these administrative warrants, ICE needs to have the consent of the school. That's why we're talking about who has authority to consent. This is compared to a judicial warrant that is signed by a judicial court, state or federal, a state or federal judge, and it will include the address of the premises to be searched or specific person identified, and it has to be executed within a limited time period that's specified on the warrant. So here is an example, and again, this will be provided in the materials if you can't see very clearly on the screen. And then here we have kind of side by side judicial warrant that you can see at the top has the name of the court, a United States District Court. It's going to have a specific matter listed with an address that you need to check to make sure it's the right space that is being approached with the warrant. Is it still current? Is there still time within the period identified on the warrant? And is it signed by a judge that's identified clearly on the document? That is in comparison to the other side of the screen that has at the top Department of Homeland Security or DHS, Immigration and Customs Enforcement, warrant of removal or deportation, and is signed only by an immigration officer at the bottom. This material is available from the National Immigration Law Center, and they've got a good resource that I'll link that has, even more detail about these distinctions. But no layperson should be required to look at a document and make sure that it meets all of these standards, which is why we absolutely suggest that a school's lawyer needs to be contacted immediately if there's an approach from ICE enforcement officer, and that lawyer is looking at these documents and making a determination. So if you do have a valid judicial warrant, school staff, after verifying with your school's lawyer, have to comply as written only within the scope of that document. So while that is happening, school staff need to contact also a parent or child identified, and certainly need to provide supports even before you get to this point, but certainly if you're here with ICE contact at a school, provide supports and have a plan for additional counseling and processing opportunities for students within the school, because this is going to impact the whole school climate. We have here some specific procedures. This is drawn from a sample, again, which I'll provide with the materials, that were created by another Pennsylvania school district team for their school staff. And this is the type of specificity that we really think is needed here, so that nobody has to try to think on their feet when the first step is always wait. I'm not able to make this decision for you. Please wait here. I can't give you access. There's no entry beyond this point, and contact the administrator with authority and counsel to review the request. But this type of very specific examples for the secretary or the security guard in the main office that is going to, answer the door at the school. This is our school board policy. We don't allow any law enforcement officials without verification to enter. Please give me name, badge number, and agency affiliation that I can pass on to my principal or superintendent. And this type of scripting is really helpful for folks to get clear in their heads what you can and can't say, what's the appropriate next step. We also have this for school bus drivers who may be approached by ICE. We have unfortunately seen nationally more ICE enforcement activity around the outside of schools, around bus stops. And while a school bus that is operated by an LEA or an agency contracted by the LEA is non-public, private space, and would require consent to access, I don't have any authority to point to that has established that the bus stop itself, the space on the sidewalk where a student is waiting, could be considered private, non-public space. That is the public sidewalk. So it's really important also for schools that have busing systems to consider these various scenarios as well. In Los Angeles, United School District, for example, they added more bus stops to decrease the amount of time that kids have spent walking to and from the stops, and to decrease the number of kids waiting at any particular stop because there was such activity around bus stops and in and out of bus times. We want a specific protocol for the bus driver to follow. And here in Pennsylvania, you can cite this statute that says it is unlawful for anyone to try to access a bus without authority. The suggested protocol, I think, again, it's going to be specific to circumstances, but what I have discussed with folks is that, for example, if the bus driver is coming along and you already see ICE agents around the bus area, your next stop, to immediately call in that report to the school administrator to get that, through the lines and make sure that there's support activated there. But that bus keep driving. Don't stop, because that would just prompt an engagement that you don't have to do. You don't have to engage there to keep driving, but call it in so that other supports are sent as soon as possible to that area. Regarding student records and FERPA. FERPA is the Family Educational Rights and Privacy Act, and it generally prohibits schools and school districts that receive federal funds from releasing personal information contained in the student's education record without the written consent of the parent or guardian or that adult student once they turn 18. The general practice, of course, is to disclose student education records to school officials and staff that have a legitimate educational interest in that particular information, or, for example, another school to which that student is transferring. There are exceptions that schools can disclose to law enforcement officers or ICE only if they have a valid court order or subpoena. And that is going to require, again, attorney review. And you have to, under the law, provide advance notice to the parent or guardian of the student identified before the release of the information, because they have the right to seek a protective order in court before that information is released. There's another health or safety emergency exception, but is extremely limited, and it only permits disclosure when necessary due to actual, impending, or imminent emergency disaster, terrorist attack, outbreak of epidemic disease, and that's to a particular school or district. It can be generalized as a possible emergency somewhere in the country. So schools are really required to make a reasonable effort to notify the guardian or the eligible student in advance of this compliance with any subpoena for records so that they can seek protective action in court. There is another type of records or information in a student record that's called directory information. And this is defined as information that about a student that would not generally be considered harmful or an invasion of privacy if disclosed. What many parents often don't understand is that the school decides what exactly is included in their designation of directory information. And what I've seen is that many schools don't reconsider this very frequently, and it can be very broad and include lots of information. So we really urge, we really urge schools to dig into this and consider whether you can narrow that designation of directory information so that it does not at least include place of birth, which is certainly a sensitive piece of information for many immigrant students, particularly in this context. Also of note, families too often don't know about their right to opt out of sharing this directory information. So that's a form that I know my child's school sends home at the beginning of the year, and it's in a big packet of information, and it's not something many parents usually spend a lot of time on. But we really are urging, particularly now, that schools ensure families all have accurate notice about what is in this directory information designation and have another opportunity to opt out, to send that information slip home to all students and clearly identify the opportunity to opt out. Parents or advocates working with parents can use a template fact sheet that I have linked here from ELC if it's not immediately clear to you from your school's website what form to use. We have just a pause here to note also that school security officers may, depending on the different roles and characterizations of security officers in our schools, be a place of confusion about their role with respect to law enforcement action or ICE action. As with any school staff, an SRO or security officer should have access to confidential information in the education records only if they are designated as a school official, which is defined to mean that the school has direct control over that officer's maintenance and use of the education records. Not always the case, depending on how your officer is designated. And that officer has a legitimate educational interest, meaning their review of the education record is required for them to fulfill their individual professional responsibility, or they shouldn't even have access at all. Certainly when they do have access, they are under the same obligations to retain confidentiality of the records and to not share it beyond necessary within the duties of their role. So they can't share it to other law enforcement officers or school officials outside a particular task for that legitimate educational interest. So again, because this area of school security officers can be a little bit fuzzy depending on the characterization and the role that they take, we really recommend sitting to think through with your lawyer and your administrators and make sure that the security officers understand all their obligations here too. For FERPA violations, there are some options here to impose a 5-year rule ban against any community-based organization if it's determined that information was shared improperly, but there is no private right of action under FERPA. There may be other damages to be considered in a private suit depending on how the circumstances present. Okay, I know I'm moving quickly, but trying to save time for some questions. So some recommended protocols, and again, these will be linked in the material provided, but just to review, schools must consult with their legal counsel to prepare for potential immigration enforcement. We know that there's a lot of noise in the news, but it is I think everybody tracking this does think that there is a very likely surge in Pennsylvania and certainly Southeast PA. So we need everybody to be considering and preparing for these potentials. It is really valuable to have a welcoming schools policy from the board that makes clear to the entire community your commitment to all students' safety and inclusion in school, and to have specific internal protocols of the types that we talked about, and additional types about arrival and dismissal times and when you might hold students and how you're going to communicate that to families. There's a lot of specific potentials to consider that staff need to be aware of and trained on, and that have to be communicated to families so that everybody is trusting the process that will be followed and able to work together on this. Certainly you want to clearly mark public and non-public areas for all the reasons we discussed earlier. And when if an agent comes to the school or around the school, you're going to follow the steps that we identified. I'm going to move to supports for parents and students. Again, you just want to communicate with all families in all the languages that are needed, in all the forms that you can, right? Like, so parents often get just a form letter home from school, and depending on the responsibility of your child, that might get lost. So, text messages, links to video messages from school leaders that are then translated in multiple language, like really multiple ways to share information have to be accessed here. It's important to, again, provide multiple opportunities at multiple stages for all families to update their emergency contact and permissions for pickup. Because if a family member is detained, the school needs to know who is next in line and next in line and next in line, who also has access or permission, to pick up that child. And we also encourage families to list a trusted agency or organization if you don't have specific names or in addition to your specific names. So if it is an after-school program, certainly list that organization. If it is an agency that provides services to your family that you trust, list that agency as well, so that there are multiple options for school staff to call so that that child doesn't end up waiting with nobody for pickup if the family is detained, or if, contacting DHS, local children and youth agency for engagement if there's no support available. We talked about considering the data that's maintained and providing opt-out forms for families. It's really critical that schools are a resource and hub of information about other Know Your Rights information as well, and providing that information to families, and again, multiple different forms. And there'll be more resources available in these links as well. So to recap, consult your legal counsel about all of this and establish a robust Welcoming Schools Board policy and very specific scenarios for all of these different, very specific protocols for all these various scenarios that can be presented, and then train your staff on them and have drills the same way that we do for lots of other frightening engagement opportunities that schools have to prepare for. Talk with families, provide the Know Your Rights, establish a school community sanctuary or response team to share information about what's happening around the school with staff inside the school, and to make those determinations about whether student movement needs to be restricted at any time and how that's communicated to families. For individual engagement, we have opportunities here that folks need to be explaining the state of the issues, reassuring and connecting with community. You can submit a letter to your school board or superintendent. Certainly there are advocacy opportunities. If you follow Education Law Center Pennsylvania, we provide those whenever we have one to do. So I'm going to pause here, Megan, and we'll defer to you about any question opportunities.
Thank you, Kristina.